Every day in the USA, people find themselves in court.
Next up is file number 251368CK, and the matter is captioned Bouchard versus Barton Smith DBA Classic Auto. So I do see Mr. Hessian here, counsel on behalf of Mr. Bouchard. Would that be the gentleman seated to your right?
Yes, Your Honor.
Okay, and then we have Mr. Smith seated with his attorney, Mr. Albert.
Correct.
This is defendant's motion for summary disposition. I have read the motion, the brief in support, the response, the brief in support of the response, and the reply. So assume I understand the material when you make your arguments, which, Mr. Albert, you may do so now.
Right. Thank you, Your Honor.
You're welcome.
Thank you for taking the time to read everything.
Always do.
I do believe that you are well apprised of the facts. I just wanted to reiterate a couple of the pertinent ones that are basically central to my argument. That being that the plaintiff alleges that the contract was formed on February 19th, 2018, that there was a flat rate fee of $23,000 for a full restoration of a 1972 Cutlass, that as of July 1st, 2018, the plaintiff had paid defendant $31,000, which he specifically alleges was $8,000 over the contract.
Yeah, but Mr. Albert, look at your affirmative defenses. How do you get around your own statements that it was not a flat rate of $23,000?
Well, Your Honor, I don't think that my affirmative defenses are necessarily relevant to this motion standard. This motion standard requires the court to look at plaintiff's allegations and take them as true unless there is
But then you also call it a modification in paragraph 6 of your affirmative defenses. Don't you got to live with your own statements?
Correct, but again, this motion standard doesn't incorporate my affirmative defenses.
Why does it not?
I am unaware of any law requiring.
You're telling me that the court for motion practice can't attribute statements you made to you?
They can, Your Honor, but for this specific purpose, we're looking at the allegations that plaintiff made, not the arguments that we've made in defense of that. We've also denied any wrongdoing. And for the purposes of this motion, all of the allegations of wrongdoing are taken as true.
Well, under a C7 motion, the court considers all pleadings, right? Including yours.
Correct, but under any C7 motion, then anytime a defendant denies wrongdoing, but then claims that the statute of limitations has in their answer, but then claims that the statute of limitations bars the complaint, it essentially would render the motion moot because we've denied any wrongdoing. But for the point of a statute of limitations argument, we have to accept those allegations as true.
Do you agree that if the extra money's given was a modification, that you would not prevail on a C7? Do you agree with that?
On the breach of contract claim? Correct.
But you're saying I can't use what you say against you, though, in your affirmative defenses. That's also your position?
I would say that based on the motion standard, it isn't relevant.
Do you have authority for that?
I don't.
Okay. I'm sorry, I took you away from your argument. You can.
I'm also, but Your Honor, I'd also say I looked into the matter because the plaintiff raised it, and I didn't. The plaintiff also didn't supply any law in support of that. And
why does the plaintiff have to support law when they want to use your own pleadings against you? Look, the bottom line is,
it's the same argument.
Excuse me. C7 motions consider pleadings and documentary evidence that includes affirmative defenses. That's just the way it is. So go ahead with the argument.
Okay. The plaintiff alleges that there was no modification to the contract, that it was a flat rate, and that he paid $8,000 over and above. There's also allegations in the complaint under his MVSRA, the Michigan Vehicle and Repair Service Act, that he conducted repairs that weren't specifically authorized or pursuant to the complaint. That would also, I would argue, constitute a breach of contract. Now, again, there is not a specific allegation, as I outlined, regarding when those were made, but as of July 1st, my client was requiring him paying more, and to me that would indicate. I'll move on from that argument.
Thank you.
I understand it's not the strongest, but the point being that there was a very specific allegation regarding the terms of this contract. The first breach of those terms occurred on or before July 1st per the pleadings. That is more than 6 years before plaintiff brought his claims, and the plaintiff agrees that the statute of limitations for a breach of contract is 6 years. Continuing along this line of argument, the Blazer Food Court, or the Blazer Foods Court, they analyzed a very similar situation in which there was an ongoing relationship with several breaches of contract, and the plaintiff wanted to apply the statute of limitations only to the last breach, or to the breaches that occurred afterwards, while also asserting damages related to previous breaches. The court denied that argument, relating it back to the initial breach of contract, and denied the plaintiff's claim based on a statute of limitations. Moving along to plaintiff's claims for fraud and misrepresentation, plaintiff relies on the same factual allegations to support both claims. So we're talking about for each claim, the factual date or the dates that he's alleging are the same. And he says specifically in his complaint that the defendant made fraudulent statements and misrepresentations of material fact at the time that they entered the contract on February 19th, 2018. Whether or not this court, and they also agree that there's a 6-year statute of limitations applied to claims for fraud. Under MCL 600-5827, the claim accrues when the wrong upon which the claim is based is done. So whether this court considers the fraudulent statements made as the wrong done, the entering of a legally binding contract, which then bound plaintiff to fraudulent terms that he didn't agree to, allegedly, whether or not it was the representation that $23,000 was the flat rate price, all of that would have occurred, and a financial damage related to that $23,000, all of that would have occurred at the latest on July 1st, 2018 per his pleadings. Now, that is of course 6 years before, that is more than 6 years before he filed his complaint. Plaintiff requests or states that the claim for fraud accrues at the time that the plaintiff can plead all actions, or all elements of the action. While he doesn't use the words, it's essentially a discovery rule. It's essentially applying a discovery rule to the case. Now, he cites to the Schanendorf, I believe it was, Schadendorf, if I'm pronouncing that correctly, to support that argument. That decision was issued shortly before the Trentadue v. Gorton case, which flatly rejected that line of argument. That, and I can go through the fact, I'm sure you're aware of the facts of Trentadue v. Gorton. And in that case, they flatly rejected essentially an identical argument. Here, I would say that applies, and that the breach of contract, or the fraud and misrepresentation claims accrued at the time at which the wrong upon it is based was done, which again, whether it's the making of the fraudulent statements, him entering a legally binding contract, or suffering a financial loss based on that, based on those fraudulent statements, that all occurred at the latest on July 1st, 2018. Moving on to plaintiff's claims under the Michigan Vehicle Service and Repair Act. That is obviously it's a statutory right to bring a private action for violations of the statute. He outlines several violations, several of which explicitly occurred at the time that they entered the contract, so February 19th, 2018,
Do you believe that the document, the captioned estimate of auto repairs signed by the parties on February 19th of the year 2018 is the contract that controls this case?
Based on our earlier conversations, I'm hesitant to answer.
This isn't a trick question. I'm just curious.
I believe it's a reflection of the contract, certain terms.
Is there another writing that the court's not aware of?
Not that I'm aware of, and not that plaintiffs made me aware of.
Fair.
Or that my client has made me aware of. And I'll stop there. But those allegations in the complaint about the date, and it's dated that day.
I mean, both parties signed it. It seems to be an offer acceptance and consideration.
I would say that there is several allegations of many terms that are not reflected in that document. And if that document is considered the entirety of the contract, it's simply a list of estimated labor.
It is. I agree.
So to get into whether or not, I mean, again, it's taking the plaintiff's allegations as true, accepting that as true. That's the date that it was formed. And
Pardon me?
as far as I'm concerned, accepting the plaintiff's allegations as true, that's the date that it was formed.
Okay.
Now, the allegations made in paragraph C, or subparagraphs of paragraph 40 of the complaint, C, J, and K, it all alleges a violation that occurred at the time the contract was formed or at the time work began on the car. Accepting his allegations is true. That is February 19th, and there's not a direct allegation of when work began, but it had to have begun prior to July 1st because he alleges that the defendant was threatening to, or was refusing to continue work on that date. All of those violations of the statute are outside the 6-year statute of limitations, having happened in between February and July of 2018. Plaintiff's allegations made in subparagraphs A, B, G, H, and I all are related to misrepresentations, misleading statements, or failure to disclose material facts. Again, as we talked about under the fraud complaint, or the fraud claim, he makes no other specific allegations of those fraudulent statements, of those misrepresentations, assuming that they are the same, because I am unaware of any reason, whether it's in the complaint or otherwise, what other statements he's talking about. Those violations, as we've talked about with the fraud claim, accrued beforehand. And moreover, he alleges, again, specifically on February 19th, 2018, the defendant made material misrepresentations and fraudulent statements. So there's a direct date given on misrepresentations and fraudulent statements, and that's the only date that he uses. Finally, the last subparagraph is E, and that's, again, completing and charging for repairs that are not authorized. It's my argument that the $8,000 over and above the $23,000 contract price represents those repairs. If $23,000 is allegedly supposed to cover everything, the additional repairs it would follow were not, that caused the price to increase, weren't authorized. And then moving on to my C8 motion for exemplary damages, this is specifically limited to the claim for exemplary damages under the Michigan Vehicle and Service Repair Act. If it's a statutory right to bring the claim, the statute specifically has to include a provision allowing for exemplary damages. It doesn't include that. It allows for double damages, and they've requested double damages, but it doesn't allow them to include exemplary damages on top of that. As far as their tort claims go, it again, I mean, this is kind of separate, but it's not a separate cause of action necessarily. So if this court finds that the other claims the fraud claims are barred by the statute of limitations, then the exemplary damages is taken care of through that.
Yeah, it's not its own cause of action.
Huh?
It's not its own cause of action.
Yeah, exactly. It's a form of relief, but I guess essentially the CA is technically requesting, because it's listed as a separate cause of action and specifically identifying the Michigan Vehicle and Service Repair Act, just that it's ruled that that isn't a claim or a recovery that can be brought under the act.
All right. Thank you, Mr. Albert. I appreciate you being prepared. Mr. Hessian, then, your response, please.
Thank you, Your Honor.
You're welcome. You'll get a final opportunity to speak because it's your burden.
So, Your Honor, the parties agree that the applicable statute of limitations is 6 years as to both the breach of contract case and the fraud claim. The question becomes, when did this accrue? I think Your Honor hit the nail right on the head. What happened here was there was an agreed upon price. My client ended up paying money above and beyond that. That was indeed a modification and a ratification of what they agreed on before. He was going into this with good faith, thinking that, you know, he was going to get a car worth $50,000 when it was all done. He simply thought the estimate wasn't high enough.
But didn't you just kind of catch a break with those affirmative defenses, Mr. Ashton? Because you allege in your complaint that it's just a flat $23,000.
Right. It was a $23,000 complaint, or that's what the contract called for.
And do you believe that that contract is that estimate I discussed with Mr. Albert, estimated auto repairs dated February 19th of the year 2018?
Yes,
is that the contract?
Yes, Your Honor.
Why did you not attach that to your complaint?
That was a clerical error, Your Honor. I referenced it as Exhibit 1 to the complaint. I'm not 100% sure, but I'm pretty sure. I have two secretaries that I'm working with, Deb, who's working on this more recently. I think she simply forgot to attach it. It would be very much out of character for my other secretary, but I did miss that. That was a clerical error. I wasn't aware that counsel had sent an email saying he hadn't gotten Exhibit 1. But Exhibit 1 is what we've attached to our response.
Okay. But it hasn't been filed, though. I mean,
It hasn't been officially filed with the complaint.
well, officially or otherwise, you go to Exhibit 1 in your complaint, there's just nothing. You agree with that in a court file?
I do agree with that, and I would respectfully request that you allow me to just file that amended complaint for the purpose of attaching.
Well, we'll see.
Okay. So, Michigan law is very clear, Your Honor. We say at the case of Carpenter versus Smith that a breach of contract occurs when the party refuses to perform. That happened in September of 2019. At that time, the defendant told my client he wasn't going to do any further work on the car, and he returned the car from his shop in Byron to my client's house on a truck in Saginaw. The other way a contract can be breached is in Woody v. Tanner, performance that does not conform to the requirements of the contract. And that was very apparent in September 2019. My client listed all those problems, including the car wouldn't even run when you put it in drive. He listed all the problems with the car in his affidavit. So the breach clearly occurred in September 2019. And my client filed his case within 6 years of that. Your Honor, on the fraud claim, again, we cite it in our response brief that for this type of tort action, it's not actionable until all the elements are in place. All the elements were not in place until September of 2019. The claim wasn't ripe until 2019. If I had filed the case in August of 2019, the car would have still been in the defendant's possession, and he could rightfully argue, well, on this contract, which has no time in it, and we're roughly a year and 7 months into it, I'm still working on the car. So the claim wasn't ripe until 2019. So that's when both the breach of contract claim accrued September of 2019, as well as the fraud claim.
So how do you survive summary on the fraud claim if your allegation is that the fraud occurred on February 19th, 2018?
We have 6 years.
Okay.
Yeah, you have 6 years, Your Honor. And I do want to make a few comments on counsel's reply brief. He's arguing cases that go to the discovery rule. And the law is clear that the discovery rule does not apply to fraud claims. It's clear that it does not apply to wrongful death claims. We're not arguing the discovery claim. We're saying the claim did not accrue until September of 2019.
What count did not accrue?
Both the breach of contract and the fraud claim. Because if you look at September 2018, he still has the car. He can still do right and fix the car. So when he delivers the car back to my guy in September 2019 and it's in a mess, that's where the breach of contract arises. That's where the fraud claim arises.
But doesn't the fraud claim arise at the time that they entered into the contract?
No. So they entered into a contract. At that time, there was no damages at that time. The case law is for a tort to arise, all the elements have to be in place for the claim. So again, if let's assume just for the sake of discussion that all the facts were the same, and I filed my case in September 2018.
Well, your complaint alleges that defendant made representations to induce the contract on February 19th of the year 2018.
Right. So those are the underlying facts. But as far as the claim accruing with all the elements being in place, that did not occur until September 2019.
That's when he returned the car?
That's when he returned the car, right?
So explain to me then, Mr. Hession, with specificity as the court requires, what did the defendant do? What did he say that was fraudulent or misrepresenting?
As they were going through the contract, Your Honor, and this gets to the modification we were talking about earlier, ratification, as my client states in his affidavit, he said to him, I'm going to need some more additional money to do the job right. And if you give me this additional money, you're going to have a car that's worth $50,000. That's what he said as the contract was going along. So, again, if he
you're claiming that no tort claim accrued at the time of the contract.
That's true, yes.
Okay, go ahead.
Yeah, so it wasn't, now, the fact of the matter is, I mean, he discovered the fraud later on, but we're still not arguing the discovery rule. What we're saying is the claim accrued in September of 2019. That's the first time that he was aware that he didn't do the job, and then he had damages in September 2019.
That's not what you said in your complaint. That is completely not what you said. I'm looking at your complaint now. Paragraph number 16, count 2, fraud, February 19th, 2018. Defendant made the following statements. These representations by defendant were false when defendant made them, which tells me I got to look back in time, not forward. Defendant knew the representations were false when he made them, February 19th, 2018, or made them recklessly without knowledge. How do you skip ahead in time, Mr. Hession, when your complaint clearly does not?
Well, if you look at, if you continue reading, Your Honor, he acted in reliance upon the statements, and 31 says, as a result, plaintiff was damaged.
Why do I have to look ahead? Why can't I learn everything I need from paragraph 26 and 27?
Because while those are the facts, the legal issue is when did the claim accrue? And for any tort, the claim accrues when all of the elements are in place.
But 26 lists the facts, 27, defendant made the representations and that they were false. 28 knew the representations in 26 were false. Where do you say he made representations in September?
I don't. What I do say is that as a result of him acting on reliance upon those, he suffered damages. So the question becomes, when did he suffer damages? Because the case law that I've cited, and I can go back to it, Your Honor. Okay, so the elements of fraud, and this is in Highway Motor Company versus International Harvester Company, 1976. Number one, the defendant made a material representation.
Well, look, I'm aware of the elements of fraud, Mr. Hession.
Yeah, so if we read that through, element number 6 is that he thereby suffered injury. Okay, so in order for the statute of limitations to start running for the claim to accrue, you must have all the damages in place. He didn't have his damages until September 2019, when the car was brought back to him, because he's, up to that point, he's working with this guy, and, for instance, in August 2019, he still could have done the work. So he didn't have a claim until 2019, September. And we're not arguing the discovery rule. What we're arguing is that the claim did not accrue until the car was brought back to him in September of 2019. And that's the first time he suffered damages.
Okay.
Did you have any other questions for me, Your Honor?
I don't.
And finally, on the C8 motion, the C8 motion pertains to exemplary damages. It's clearly not a separate count. But as an element of damages, it's a form of compensatory damages, which compensates the plaintiff for indignation, shame, embarrassment, what have you. We pled that as it relates to the fraud claim, and the Motor Vehicle Act also prescribes that type of fraud. Counsel's argument is that because the Motor Vehicle Act has double damages and doesn't say exemplary damages, that we don't get exemplary damages. It's our argument, Your Honor, that we do get exemplary damages for the fraud. And that's what we pled in our complaint.
Thank you, Mr. Hession. I appreciate your preparedness as well. Mr. Albert, you're up next. You get last call. It's your motion. You have the burden.
Thank you, Your Honor. As far as the accrual of the claims, specifically, first the breach of contract, the Carpenter case, and I discussed this in my reply, while it's talking about a land contract and anticipatory repudiation, it says that the plaintiff can sue immediately upon an unqualified refusal to perform. And I'm not trying to reiterate our discussion earlier regarding the July 1st.
Yeah, it does. But
that is the outline. That's the outline of our argument, is that they're claiming, and to the extent that we're held to our statements, and I know it's my motion, but they made statements and allegations in their complaint that
which ultimately then would be a question of fact, right?
No, they made an affirmative statement that he refused to perform under the contract on July 1st.
And then, but you said that there was that in your affirmative defenses that there's a modification.
However,
however leads to a question of fact, right?
However, the agreement, whatever agreement occurred for them for an $8,000 payment over and above the contract price, they allege that before that, there must have been a refusal to perform. They say that he refused to perform. Under Carpenter, it specifically says that an unqualified refusal to perform allows the plaintiff to sue immediately.
Unqualified?
Unqualified. And if he's refusing to perform, and then there's a modification with $8,000, the initial refusal would have qualified as a.
Okay.
So their own case law, I would argue, supports that argument. The follow-up case law is that anything they also specifically allege that from July of April of 2018 till he returned the car in September of 2019, he carried on a scheme of defrauding and extorting plaintiff for additional payments. Now,
I'm all set with fraud. If you don't have anything else, I don't need to hear any more about fraud.
On fraud, okay.
Yes.
I would, if you don't want to hear any further arguments on fraud.
Well, I'm good with fraud. I completely understand, and I know I'm going to rule on that issue.
Okay. And if you're done with my arguments on breach of contract as well.
Yeah, I'm all set.
I am too.
I appreciate it. Thank you. And I'll tell you, both attorneys did a really good job of presenting material to the court today. And I sure appreciate attorneys that advocate for their clients. But the court is ready to rule on defendant's motion. Plaintiff's complaint alleges 5 counts. Count 1 is breach of contract. Count 2 is fraud. Count 3 is an intentional misrepresentation. Count 4 is a statutory claim. You know, we've got kind of a booster, hearing booster, if that would help you.
It's just.
You want a little handset hearing booster? That help? Would that help you? You're good? Okay.
I gotta hold it here. I don't hear everything. This vibrates too much.
Did you give him that thing? I didn't even think, I just saw you just now cupping your, here, check this out. This might help you. How's that? Does that help you out? Is that better? All right. That work for you?
Push it right.
Yep, it will.
Oh, this button. Okay. All right.
Okay, but you can't keep it. You got to give it back when we're done.
All right.
So I'm just going to start over again so Mr. Bouchard can follow along. So this is plaintiff's complaint, and it alleges 5 counts. Count 1 is breach of contract. Count 2 is fraud. Count 3 is an intentional misrepresentation. Count 4 is a statutory claim. Then there's a second count 4, presumably intended to be count 5, seeking exemplary damages. Defendant seeks summary disposition under C7 based on the statute of limitations and C8 for failure to state a claim upon which relief can be based. The court won't engage in a detailed resuscitation of the standard of review applicable to each court rule. The attorneys did a pretty good job laying that out in their briefing. However, it's worth noting that the court is precluded from considering evidence outside the pleadings under C8, while C7 does not involve that limitation. And the court's just going to rip the bandage right off. Some level of summary disposition is appropriate here today. Under MCR 2.113C1, when a claim is based on a written instrument like a contract, that instrument must be attached to the complaint. I know Mr. Heshian talked about that a little bit. Plaintiff's complaint does reference a contract attached as Exhibit 1 to the complaint, but no written instrument is actually attached to the complaint in the court file. Mr. Heshian calls it an oversight, then that's fine, but for today's purposes, the breach of contract claim does not survive scrutiny under C8. Admittedly, that could be cured by an amendment attaching an amended complaint. as Mr. Hessian suggested earlier in his argument. But the court can deny leave to amend for futility, so it must consider defendant's statute of limitations argument relative to this count. Neither party disputes that the breach of contract claim is subject to a 6-year statute of limitations. Plaintiff filed this case on July 17th of the year 2025, meaning it would only be timely with respect to claims accruing on or after July 17th of the year 2019. Defendant claims that the breach occurred on or about July 1st of the year 2018 when he purportedly demanded additional money from the plaintiff. That would make plaintiff's breach of contract claim untimely, as it would be filed outside of the 6-year period. Plaintiff argues that the breach occurred in September of 2019 when defendant returned the car to the plaintiff. In support of this argument, plaintiff points to defendant's own affirmative defenses, which states that the $23,000 agreement was not a flat rate and that additional payments were ratified modifications to the contract. The court agrees with plaintiff that defendant's affirmative defenses do suffice to create a genuine issue of material fact as to when the breaches actually occurred. If the conduct in 2018 was a novation or some other modification of the contract, the 2018 refusal to finish would have been waived in favor of a new contract. The breach of contract claim would not be subject to the statute of limitations, as the breach would have occurred to the modified contract in September of 2019. The court therefore denies summary disposition of count 1 under C7. However, the court agrees with defendant that plaintiff's claims for fraud and intentional misrepresentation are barred by the statute of limitations. Again, the parties do not dispute that the limitations period is 6 years. And under MCL 600 Tech 5827, tort claims generally accrue at the time the wrong was done, regardless of the time when damages results. Plaintiff's complaint clearly alleges that defendant made misrepresentations to induce the contract on or about February 19th, 2018, making any claim arising from those misrepresentations, unfortunately, untimely. The court does grant summary disposition under C7 as to counts 2 and 3 of the complaint. The court next looks to plaintiff's statutory claim under the Motor Vehicle Service and Repair Act, MCL 257 TAC 1301 at SEC. Plaintiff did not separately respond to this topic in defendant's motion. The court came very close to deeming this issue abandoned. But the court is also mindful of the imprecise allegations raised in this count of the complaint and the difficulty of associating them with specific dates. The act does not contain its own statute of limitations, so the court applies the general 6-year period of MCL 600 TAC 5813. To the extent plaintiff's statutory claim involves conduct occurring before July 17th, 2019, the motion is granted under C7. To the extent the claim involves conduct after that date, the motion is denied. Next is plaintiff's claims for exemplary damages. This claim derives from plaintiff's claims for fraud and intentional misrepresentations. Without those two claims, the request for exemplary damages cannot survive. Moreover, the court agrees with the defendant that exemplary damages, it's a remedy, not an independent cause of action. The court will grant summary disposition under C8 accordingly. One other issue is that when the court grants summary disposition under C8, it's generally required to grant leave to amend unless the amendment would not be justified. Amendment is clearly justified as to the breach of contract claim, since this is a matter of merely attaching a copy of the contract to an amended complaint. As to the two tort claims, the court is not required to grant leave to amend, and the statute of limitations would make any amendment futile. However, if the plaintiff files an amended complaint, he is also instructed to clarify which statutory violations occurred after July 17th, 2019, or we will be right back here on another summary disposition motion. Amendment is, however, futile as to exemplary damages, since that's a remedy deriving from two dismissed counts. To summarize, this is the following ruling Mr. Albert, who will be preparing the order. As to count 1, breach of contract, the motion is granted under C8 on the court's own motion, but denied under C7. As to counts 2 and 3, that's fraud and intentional misrepresentation, the motion is granted under C7. As to count 4, that's the statutory claim, the motion is granted under C7 as to any conduct occurring before July 17th of the year 2019 and denied with respect to any conduct that occurs after that date. Any amended complaint must clarify the dates of the alleged violations. As to count 5, exemplary damages, the motion is granted under C8. That is the court's order. Mr. Albert, do you need anything else to prepare that order?
No, I'm sorry, Your Honor. Can you just reiterate the date from which the MVRS claims are barred?
July 17, 2019.
Thank you.
Okay. Thank you very much, counsel. Enjoy your weekend.
Your Honor, thank you, Your Honor, for your ruling. In the court's order, counsel is preparing, should we also put in there that a certain amount of time plaintiff is allowed to file his amended complaint?
Well, how much time do you need?
A week, I guess. I don't need a lot of time. 21 days, maybe? Well,
The problem we run into, Mr. Hession, is that your trial date's at the end of April. Is that going to affect your ability to be ready for trial, Mr. Albert?
It should not, assuming that there's not anything added to the MVRS.
Fair. Well, he is going to have to nail down his dates on.
Exactly, which will actually help me prepare.
All right, good. So how about 2 weeks? Is that fair?
I'm sorry, Your Honor?
2 weeks?
2 weeks would be fine. So may I do a separate order allowing the amendment, or do we want to wait for your order? I don't know what Your Honor wants us to do.
Mr. Albert can just include that in his order. It's going to be 2 weeks from today's date, not 2 weeks from the date of the entry of the order.
Okay.
So it doesn't matter.
All right. Okay, thank you.
Do you have what you need, Mr. Hession?
Sorry?
Do you have what you need?
I'm all set, Your Honor.
All right, Mr. Albert? All right, thank you, gentlemen.
Thank you for your time, Your Honor.
You're welcome. We need our hearing thing back.
The car collector wanted a shiny dream machine, but the mechanic kept asking for extra green. 6 long years arguing about the date, while the classic ride sits in a broken state. The lawyers talk circles about when the clock starts to tick.